Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here this afternoon for the submission of 3 cases. The first case is the State of Jill Cataldo versus RCH Piatumwa, and that is hereby submitted without oral argument. The first oral argument of the afternoon is Baldwin versus Central Iowa Hospital, and it looks like the parties are ready to go. Mr. Kappelman.
May it please the court. My name is J.R. Kappelman, and I represent Iowa Methodist Medical Center in this appeal. If this court declines to adopt the preemption rule and the district court's denial of summary judgment is permitted to stand, Iowa Methodist Medical Center, IMMC, will be forced to defend 2 separate claims of medical malpractice in the same lawsuit. In addition to the claims based on the care provided to Mr. Baldwin, IMMC will also have to defend, relitigate claims that are totally unrelated based on a lawsuit brought by a separate patient's estate. The lawsuit resulted in settlement, and we will have to defend those claims, IMMC will, under the guise of a claim of negligent retention. If that is allowed to occur, IMMC will defend these 2 separate claims, even though plaintiff's path to recovery is entirely dependent on establishing the negligence of the employee involved, Nurse Klein. Even though IMMC has acknowledged liability for her potentially negligent conduct through respondeat superior, and even though the negligent retention claim provides no separate path to damages for plaintiff. Worse yet, this situation will not be limited to this case or this defendant. Employers across the state will have to defend duplicative claims of negligence and negligent retention, negligent hiring, negligent supervision. And the judicial system will have to manage the litigation of those claims, even though the plaintiffs in those actions will not be able to recover additional damages, and even though they do not have an independent path to recovery.
So I understand the argument, but it seems, at least in practice, we've allowed this. I've identified at least 12 Court of Appeals decisions and a couple of ours that do have negligence claims and negligent retention claims at the same time. So how do you square that with your position now that it should be disallowed?
Your Honor, it doesn't seem clear to me in those opinions that you mentioned, I believe that I'm familiar with, that this issue really ever came up. It appears that this is an issue of first impression for Iowa's appellate courts. And I don't know why that is in those other cases, but what I can say is that the reason it should be disallowed now, the strongest reason, is that adoption of the preemption rule is most consistent with a couple different aspects of Iowa law. In other words, rejecting the preemption rule runs contrary to principles that this court has espoused on numerous occasions involving claims of negligent hiring and retention, involving comparative fault, involving the causation standard, which has been adopted under the restatement third. So when we think about the nature of a negligent retention claim, and I'm just going to refer to it as negligent retention because I think that's really what the facts of this case are. The nature of a negligent retention claim in Iowa is...
I want to touch on something, and maybe you were hinting at it. Is there a distinction to be drawn between negligent retention, negligent training, negligent supervision for the purposes of this rule that you're advocating for today?
Believe so, Your Honor. In some of the cases around the country, there's been a bit of an exception acknowledged for what they call negligent entrustment. Not a lot of discussion about negligent entrustment in Iowa. I think since Godar, we've always kind of framed it in the training, supervision, retention, hiring route. And for those purposes, for those types of claims, I think the preemption rule would apply in basically the same way. In all those cases, for example, I think this court has acknowledged that to recover from the employer, the plaintiff must establish the underlying negligence of the employee. In other words, in Iowa, a negligent retention claim is derivative, not direct. Now, I hesitate to use that language because it's used a lot across the country, direct versus derivative, because I think it's a little bit imprecise. The real question is, in this context, where we have an admission of respondeat superior liability, and the only path to recovery is by establishing the underlying negligence of the employee, then in that context, should we allow this additional claim?
The issue of raised by your opponent, where the legislature has gotten involved in this topic with regard to commercial vehicles, but not so much here.
I think the legislature has drafted and approved a specific statute in a specific context. I don't think they've claimed the field in this area, and as this court can see from courts across the country, even where that's the case, the potential application is so widespread that it really is up to this court to decide in all contexts, can these additional types of claims survive, or are they really viable? Because the issue is not really one of legislative action, it's one of, is this consistent with the way this court has developed the law on negligent retention? What this court has said is, again, these claims are derivative. And if they're derivative, it necessarily flows that allowing the additional employment type claims are duplicative. They risk the introduction of evidence that is completely irrelevant to the underlying negligence claim, thus prejudicing both the employer and the employee. And again, they're inconsistent with a couple of aspects of Iowa law. And
A plaintiff only brought a negligent retention claim and didn't bring an underlying claim against a nurse. What would we do in that case under your rule?
I don't think that's really a practical reality of a situation that could happen where the conduct is claimed to be within the scope of employment. So here, and in most cases where we don't have intentional conduct or conduct that's outside the course and scope of the employment, that's where you normally see just negligent retention claims. But in Iowa, we have notice pleading, and as plaintiffs have argued, or as the appellee has argued, this is just a different specification. And because it involves necessarily, under Iowa law, proving the underlying negligence of the employee, where you're claiming that the employee's actions were within the course and scope of the employment, you would never, in reality, be bringing a claim just of negligent retention. And we know that because of notice pleading.
I mean, maybe in this case, if the plaintiff were forced to choose at some point later in the case, the plaintiff would determine that the additional value of including this evidence of the prior incident of patient death would be worth the additional risk that would be incurred by having to prove additional elements. I don't know. That doesn't seem like an unreasonable strategy. I'm not sure why that has to be determined at summary judgment.
Couple of things, Justice McDonald. I think, again, practically, I don't see how that would happen because you still have to establish the underlying negligence of the employee. So you're going to have, in a medical malpractice case, you're going to have expert evidence establishing that element as part of your negligent retention claim. So it's kind of a legal fiction to say we're only bringing a negligent retention claim and we're claiming that this person was acting within the course and scope of the employment. I also think, frankly, what you see in the authorities across the country is the preemption rule is a rule of practicality. If that was the plaintiff's goal, if their goal was to introduce unnecessary evidence that was undoubtedly prejudicial and not necessary to establish the negligence of the underlying employee, that's not something that this court or courts across our state should endorse.
Fact issues with this. Doesn't bringing in another party help plaintiffs potentially here?
in this context, Justice McDermott, I think that discussion has been a reason that many states have refused to adopt the preemption rule, and frankly, I don't think their reasoning is very sound. They seem to suggest that there would be a scenario where even where the employer admits respondeat superior liability, you would somehow compare fault between the employer and the employee. Now, I understand that logic, that potential, if there are separate direct claims against the employer for negligence that aren't entirely based on the negligence of the employee. So in this context, once the employer admits respondeat superior, they are liable for 100% of the damages caused by the employee through respondeat superior.
Resolve that issue first before we accept your argument? I mean, you're kind of assuming that's how that's what we would conclude, that in a negligent retention case where the employee is acting within the scope of their employment, we wouldn't have separate fault allocated to the two parties. Why not?
Justice Mansfield, I think this court has already resolved that question. If we think about, and the legislature has, because if we think about what we're doing in a comparative fault allocation, if you look at the jury instructions, the jury would allocate fault last. And if you look at Model Instruction 400.2, the instruction to the jury is that when you're allocating fault amongst co-defendants, you're not allocating a percentage of negligence. You're allocating a percentage of fault based on the damages caused by the negligence. So again, if the claim is there are damages caused by an employee's conduct, and your path to liability against the employer is based solely on that employee's conduct, like here, then you would not compare fault between the employer and the employee in that context.
Would say that that's not right, that you would actually have the opportunity to compare fault between the employer for their responsibility for the negligent retention, the employee for the act of negligence, and let's take it out of the med-mal context where this plaintiff would not have any fault, but let's say it was a car crash case, kind of these trucking cases that you see, and potentially the plaintiff. And then you would get a more accurate determination of fault among those three parties if you allowed it to go to the jury.
That just is not correct under Iowa law. And it gets back to the fact that under our system of deciding negligent retention claims, of what they are, the liability of the employer is coextensive of that of the employee. It cannot exceed that. In these other states which have pointed to comparative fault statutes as a problem, they take a different view. They view negligent retention claims as direct, and they cite things like the Restatement Second of Torts for the proposition that the liability of the employer is not coextensive of the liability of the employee, meaning you can have a direct claim against the employer even if the employee is not negligent. Now that is not the way Iowa law is, and that's not how this court has developed these types of claims. So under this court's precedent on negligent retention, and what we know about what the comparative fault scheme attempts to do in our state, that just cannot be the case.
Could you add the punitive damage claim into the mix?
I think this is a difficult question, Justice Waterman. Candidly, I'm personally, in our briefing, I'm dubious of the idea that you can have a claim that only exists to pursue punitive damages. But it is true that in most states that have adopted the preemption rule, they have built in this exception for punitive damages. If the court were to do it here, I want to make sure the question is correctly framed. It's not punitive damages under any theory. It's not punitive damages just on Nurse Klein. It's not direct against the hospital. It's only punitive damages, willful, wanton, reckless conduct for the hospital's decision to retain Nurse Klein. Now, that is a very high bar under Iowa law. We know from the statute 668A, we know from the Saraji case, this court's case, even where there have been multiple incidents. Now, that's a truck driving case, but even where there's multiple incidents indicating that the driver had a prior poor driving record, had poor driving while employed with the defendant in that case, this court said that's not enough to establish punitive damages based on the retention of the employee alone.
Runs out. I also would like you to address the emotional distress bystander issue. Am I understanding the record correctly? Was Ms. Baldwin in the hospital room with Mr. Baldwin when there was the noise and apparently the line came out? Was she actually in the room watching TV, viewing the facts in the light most favorable to the plaintiff?
I think that's correct, Justice Mansfield. She was in the room watching TV, heard a noise.
I mean, you know, normally I don't give a lot of stock into unpublished Court of Appeals opinions unless I wrote it, which I did here. And so if you look at that, that Martin versus Crooks, it does seem to be kind of similar to here, or Crook, I think it was his name, I forgot. But it was it was the same kind of thing where the event was, the person was a bystander to the event, but didn't process it at the moment, but processed it soon afterwards. Why isn't that enough?
I see my time's expired. May I answer Justice Mansfield's question?
You're really disappointed. Go ahead.
Actually, Justice Mansfield, I have to shamelessly say, I think you drew the line exactly where it is in that case, and it proves why the wife can't recover here. In that case, the Court of Appeals found that the wife could recover because she did witness the event. She didn't see the car hit her husband, but she saw him flying through the air, land mortally injured, and immediately attended to it. And that is the kind of contemporaneous observation that you need to have the shock that we tried, that is the basis of recovery under the bystander claim. But in that case, the children, who also were right there in the car, but were watching TV, just like Ms. Baldwin here, they did not witness either the contact or the immediate aftermath. Here, Ms. Baldwin, she's in the room, and I think even in the light most favorable to the plaintiffs, she's testified, I heard a loud noise, there was a lot of commotion, medical personnel started coming, and I didn't know what happened. I was taken out of the room, and I had no idea what occurred. And in that instance, she doesn't have the type of the instantaneous shock and knowledge that you have this likelihood of serious injury or death, which was absolutely present in the Martin case. If you see your spouse flying through the air after contact with the vehicle, you're going to have that.
Running at first, and then later she sees him on the ground, as I remember the facts.
I remember him a little bit differently, Justice Mansfield. I think the key distinction was there, she sees him immediately after contact flying through the air. She knew that he'd been running, so she didn't know he was there, but I believe that is the distinction between her and the children in that case. Thank you for...
Factual follow-up question. The loud noise that she heard, does record say, is that because the nurse put his bed down so she could start CPR, or was that related to whatever happened that caused the clip to come out?
May I answer Justice Ockley's question? I think it's not entirely clear what the loud noise is from her testimony. What we know is probably not the line disconnection, probably dropping the bed. She recalled that in her testimony. But basically the record's a little unclear. I think she said kabam. Thank you.
I want to raise this before Mr. Dickey argues. Is it possible that we could draw a more nuanced distinction with respect to these negligent retention claims? And it might depend on the state of the evidence at trial, where if the claim is solely related to just the retention issue only, then maybe that's duplicative and barred. But if there is some sort of independent basis that's just not derivative of merely having this person on the payroll, that you might allow those claims to go forward. So, for example, if the hospital knew she weren't licensed, I know that's not the facts here, but you could see where that might be a punitive damages type situation where they know they're employing somebody who's not licensed to provide service, or if it were negligent supervision and maybe they knew she was intoxicated, or maybe the nurse in charge was intoxicated and wasn't properly managing. So that seems more direct and less derivative, and maybe we could draw that distinction case by case and not a blanket rule.
May I answer Justice McDowell's question? I think what you're describing, Justice McDonald, is actually adoption of the preemption rule, because the preemption rule does not apply. It only applies to claims that are based on the underlying negligence respondeat superior. So in that case, you would adopt the preemption rule, but that case would proceed and the evidence would go forward. And we know that because in those instances where you have a true direct claim against the hospital based on its own negligence, you can establish liability even if the underlying employee did not act negligently. And that's the distinction. That's why even direct and derivative is a little imprecise, because you can have direct claims like this one, which depend entirely upon the negligence of the employee, and those that don't. Those that don't aren't subject to the preemption rule. Those that do should be. Thank you.
Thank you. We'll come back to you in a little bit.
Madam Chief Justice, and may it please the court, my name is Gary Dickey from Dickey, Campbell, and Sahag Law Firm in Des Moines, appearing on behalf of Rhonda Baldwin, who asked this court to affirm the district court's summary judgment ruling on all respects. Justice May, your question gets to the principal flaw in their argument, which is the public policy arguments that my friend on the other side makes is being made to the wrong audience because this court is not writing on a clean slate. In 2023, the legislature specifically addressed the issue in terms of the preemption doctrine and found that it only would apply statutorily to commercial vehicles. And in doing so, in the explanatory notes, expressed its understanding that the current common law allows for these types of cases. And that goes to your first question, Justice McDonald, which is, the state of the case law. Why, to give my friend the benefit of the doubt, I'm not sure that there is a clear case under Iowa law in which the question is presented, so the case presentation doctrine probably saves them on this argument, but you're correct. It's been implicitly recognized, and so I think the doctrine of legislative acquiescence would apply here, and I think that's reflected in the explanatory note to the amendment to 668-12A. So if this court finds that 668 displaces the common law, then the analysis ends. There is no preemption doctrine, and we don't even need to address the public policy issues. Justice Oxley, with respect to your question, can there be a standalone claim of negligent retention? We believe we brought that. Our position is because of her negligence in the Morris case, she should not have been retained. She should not have been in the room. And that in and of itself is an independent act of negligent retention. And so that is a standalone direct claim. And so as I understood Mr. Kappelman's concluding remarks, whether we call it direct or indirect, I think he acknowledges that under those types of facts where, and I think Justice McDonald, your question got to it, where somebody wasn't qualified to even be hired. Our position is she was not even qualified to be retained.
Counsel, do you still, in that instance, though, have to show that she did something negligent or not?
I don't think so. So there could be a situation in which the jury found that she was not negligent, but should not have been in the room, and her conduct was a proximate cause. And so in that situation, you would have a breach of the standard of care, which our expert says was reckless, which their nursing manager admits under their own policy she should not have been retained, or at least that manager would not have retained her. And then if we could establish as a proximate cause, Nurse Klein's acts contributed, were the cause of the death, then we would have a standalone claim. So it's not dependent on Nurse Klein's finding of negligence.
The concerns raised by your opposing counsel be addressed through bifurcating the trial, where only if the nurse was found negligent and proximate cause of Garrett damages or his death, then you, same jury, put on the additional evidence of the prior death and the nursing expert on should she have been retained, and then any punitive damages if that's a jury question on that.
The answer is yes. There's a motion to bifurcate. It's been resisted, so I don't want to concede that bifurcation is warranted. But because of the stay in this case, the district court hasn't reached the decision. But the main public policy argument is that no preemption is confusing to the jury, and we give the jurors more credit. We give trial judges more credit through limiting instructions, through bifurcation. We can address those issues. As this court noted in the Kiesau decision in 2004, negligent supervision and retention claims by their nature, quote, must prove a case within a case. So, you know, the idea that there's going to be a mini trial, that's inherent. It's already baked into any negligent supervision claim.
Just arguing about that your negligent retention case did not necessarily turn on the nurse's negligence?
13 different specifications of negligence, one of which is the, you know, she should have been terminated immediately, but there are circumstances, setting that one aside, in which, you know, there is a respondeat superior theory of recovery.
Both in this case.
The position that we did. Now, I think, Justice McDonald, you asked, can we split the baby and limit it to the facts of this case? But for 668.12a, I think you could. But you're not writing on a clean slate, so you're not free to we don't believe that it would be proper for this court to disregard the legislature's regulation in this area. Justice Mansfield, you had asked about comparative fault. I just disagree with Mr. Kappelman's analysis as comparative fault works. I think there is a principal question in whether the parties are negligent, and once that is determined, then the second threshold question is how do we divide the pie in terms of fault, which is in relation to their negligent acts. So what we would not ask the jury is to say who, you know, the hospital is just a little bit negligent, so they should get a small slice, and Ms. Klein is more negligent, so she should get more of a slice. It's in terms of, you know, their fault in the causation, who should be attributed. I think we make a good argument, and I think it's the same argument that the plaintiff makes, or at least made in the next case, which is the hospital was in the best position to prevent this from happening by terminating her after Mr. Morris's death.
I have a question about that, and this is something that bothers me about this kind of claim, and I want you to address it. So you have a licensed professional whose licensing board says this person is qualified and competent to work in the state of Iowa. And if you're right that because of this prior accident, she immediately had to have been terminated, and not terminating her is negligence, does that mean hiring her in the future is also negligence? Because I think your position is she just shouldn't be working as a nurse at all.
Position of our expert, and what I would say is we're not arguing for a negligence per se standard. Certainly they are free to argue otherwise, and one of the facts they'll point to a jury.
I mean, you're saying that anyone who hires her is doing this negligently because of her prior treatment of patients.
I would say if she were hired to be a nurse in a walk-in clinic where she is not seeing critically ill patients, that argument may have some currency. But I don't think under these facts, and certainly our expert's opinion, is that she should not be in a critical care unit after the negligence in Mr. Morris's case. And that's a jury question. We could lose on that.
Not only is it a jury question on negligence, you say it's enough for a jury question on recklessness, right? Punitive damages. Yes. Because it does seem kind of conclusory. It's just a few sentences in an expert affidavit. There's not really an elaboration, discussion of like what are the hiring or retention standards in the medical community, things like that. You know, what are the normal, you know, do nurses ever continue to work if they've been involved in a fatality before? I mean, it's just pretty bare. Is that enough? Is that your view?
Create a genuine issue of material fact for summary judgment purposes. Obviously, at the time of trial, we will present all of that. We're trying to be lean in our arguments, and I think the district court was being lean in its analysis.
Let me get back to your discussion about the allocation of fault. Now, how would you do it if you're submitting both the negligent retention and the straightforward negligence with respondeat superior to the jury at the same time? How would you do the allocation? Do you ask them to make two separate allocations, one that excludes the hospital and one that includes it?
I think if you're asking what the jury instructions look like, I think we do specifications of negligence with respect to the hospital, which would be the negligent retention after Mr. Morrison's death. And if you find that they have breached their standard of care, then you go on to the percentage. With respect to Nurse Klein, we have a whole host of things that she did wrong. We've got the hospital also, we have the clips, so they're using a tourniquet, knowingly using a tourniquet instead of using the proper clips, so that's another specification of negligence direct. Once they find the specification of negligence, find the specifications of negligence with respect to Nurse Klein, and only if you find one or more of them would you compare their fault as to potentially a third party or to Mr. Baldwin himself. And that's, so with respect to the public policy issue, Iowa, our comparative fault system, where we have to attribute the fault, it would allow a situation where they will just discount the fault if they are considered one and the same into a situation where Mr. Baldwin conceivably could be found 51% at fault, where he would not be if the claims were allowed to proceed separately. So Justice Waterman, your question about the punitive damages, so the reason why there's a punitive damages exception is because once that evidence comes in, there's a mini trial and there's 404B evidence, and so all the public policy concerns go away. And so it's not for any other reason. And so I think the district court properly found that there is direct evidence of recklessness against the hospital, and then there's plenty of direct evidence of recklessness on behalf of Nurse Klein.
Ask you one question about a sentence in Keesaw. We have a lot of cases that have negligence claims and negligent retention claims, but as you point out, the interplay is not really discussed, or the theory is not discussed much. The best I could find is this sentence. It says, a negligent retention claim applies to allow an injured party to recover where the employee's conduct is outside the scope of employment because the employer's own wrongful conduct has facilitated in some manner the tortious acts or wrongful conduct of the employee. And as I read that, it makes it sound like it's kind of a binary situation that you would have respondeat superior, and where maybe that's contested or it's clearly outside the scope, then you would have negligent retention, which would support the preemption rule. So address that, please.
Donald, I'd ask you to go back and read Keesaw because I read it slightly differently. So that was talking about the circumstance in which it wasn't a negligent act, it was a defamatory statement that was made outside of the context of the employment relationship, but the allegation was the employment relationship made it possible for the defamatory statement to be made. That is not what we're at. We're not suggesting that Nurse Klein acted outside of the scope of her liability.
This was just applying it to the facts of that particular case and not as a limiting principle on the scope of the tort.
That's an extending principle. So the court there is saying it extends to an employer-employee relationship even outside the scope of the employment, where the employment relationship allowed for the employee to be in the position to commit the wrongful act. So we're talking about apples and oranges here. So Justice Mansfield, I do want to address your well-written and well-reasoned opinion from the Court of Appeals in the Martin decision. And I've read it several times, and I just disagree with Mr. Kappelman's characterization of the facts. And I'll specifically quote from page 22 to 23. As Andrea Martin later testified, she did not see the actual impact of Crook's car striking her husband. Only when she turned to look for David and did not see him did she realize he had been hit by the car. That's what we have here. The summary judgment record shows that Rhonda was in the room holding his hand, heard the boom, looked over and saw his eyes open, saw Nurse Klein's response and cry for help. There was a code blue, and then she was rushed out of the room to visit with a chaplain. And so we submit that it's on all fours with the Martin decision, and the distinction in the line that was drawn in Martin is consistent with the line that was drawn here, where Rhonda's children, who are in the waiting room or in the parking lot, would not be able to claim bystander liability because they were not contemporaneously observing the accident, just as the kids in the car didn't contemporaneously observe the accident. So, remember, the purpose of the line drawing is to determine whether or not the distress is from the observance of the accident as opposed to the distress from later hearing what the cause was. And so, this is not a situation where she wasn't under distress until she learned that it was a line disconnection. The whole event, observing her husband, in acute distress, was what led to her emotional distress. So in the final analysis, I think the most direct way for this court to affirm would be to find that 668.12a decides the question presented. Alternatively, we would ask the court to reject the public policy reasons that have been advanced based on the unique characteristics of this case as well as the comparative fault statute. Then we'd also ask the court to consider the punitive damages exception, if necessary, although I don't think that we need to address that. And if it does, that there are genuine issues of material fact. And then finally, to hold that the Martin decision decides the question presented. Thank you.
Thank you, Your Honor. I want to get back to one of your questions, Justice Waterman, because I felt like I didn't give you a full answer on this punitive damages issue, and I think that ties into bifurcation and circles us back around here. On the punitive damages issue, we know from Saraji that it's a high bar when we're talking about negligent retention against the employer. And the facts of that case were extreme. This court says no punitive damages. The only evidence that plaintiffs have pointed to in their brief that support punitive damages based solely on the negligent retention are one sentence in their expert affidavit, which said that it was negligent to retain her, and one note of a corrective action from her manager. There's never been any admission. There was no finding that she caused any patient's death. There's never been any admission that she caused a patient's death. That was never the conclusion of a court, of the nursing board, of IMMC. There's simply no evidence on that. Now, if the court adopts the preemption doctrine and the punitive damages exception, that's where the bifurcation issue comes in, Justice Waterman, because, again, practically, because Iowa views these claims as derivative, which I think we ultimately got to with Mr. Dickey. This court has said is a case within a case. That means your recovery depends on establishing the employee's negligence. But because that's how Iowa views it, if you don't have the punitive damages issue, you never get to the second trial because your entire compensation is achievable if you win on the first underlying negligence trial. So bifurcation, absent the punitive damages concept, is just a fiction. It would never be necessary. It would never go through. On the issue of whether the legislature has really weighed in and taken away this court's ability, I just disagree with Mr. Dickey. I think this court is empowered to construct and adopt judicial doctrines that are based on and consistent with other aspects of its law, and it should do so when doing so would give critical guidance to district courts around the state. These are challenging issues, as has been demonstrated by the briefing and this oral argument. But the bottom line is, this is not an issue that can be decided on a case-by-case basis. No matter the case, no matter the facts, if an employer admits respondeat superior liability, then the plaintiff can recover full compensation by establishing its underlying negligence case, and evidence related to hiring, retention, training that doesn't provide an independent path to liability is not relevant and shouldn't be admitted, shouldn't be an issue for the jury. It's ripe for dispositive motion. Just briefly on the bystander claim, because I think everybody can read Justice Mansfield's opinion and decide where the facts lie. But really the discussion to this point has been on element 2 of the Barnhill examination, which is contemporaneous observance. The other thing that we see strictly applied in this court and the Court of Appeals precedent on bystander liability is element 4. It's not just that you have to contemporaneously observe something, but it has to be the type of event where you instantaneously recognize the likelihood of serious bodily injury or death. That's why so many of these cases are car accident cases. Because when you see a loved one get blasted by an automobile, you instantaneously recognize that that is likely to cause serious bodily injury or death. Here, we don't have that. Rhonda testified unequivocally. I did not know what was going on. I did not find out about the line disconnection until later. This patient was resuscitated and died 12 days later of what we claim are independent causes. And think about what the plaintiffs ask this court to do. We have, any time that a patient in a hospital has a code blue or a serious medical event and the family members in the room, that may give rise to bystander liability. This is why many states around the country have limited the application of bystander claims in the medical malpractice context.
Can you define what the accident is here? I mean, I understand the basis of liability, but in a car accident, it's the car hitting, the person. What is the accident that Ms. Baldwin would have seen that would have caused her the extreme anxiety?
Plaintiff's theory, Justice Oxley, relating to the bystander claim, it's the line disconnection, which resulted in the care that was provided thereafter. That's the event at issue.
Of the line disconnection, which then caused them to have to do the CPR and the resulting actions.
Christensen, may I answer that? I think this is a great example of why the decisions have drawn the line so finely. Because in cases where the family member, for example, in the auto accident case, has arrived immediately on the scene, 5 minutes later, and CPR was being performed, that wasn't enough. So I don't think you get to bundle up the care and the CPR that's provided. We know that hasn't been true where family members have witnessed that in the auto accident case. I think that's in Finneran and the Moore case. So in our opinion, it's the event that initiates the need for care, which here would be the line disconnection and the air embolism. Now again, you don't see an air embolism, so it's challenging, admittedly. But what we know is it can include the life-saving care that occurs afterward, because our appellate courts have said it doesn't. Thank you, Your Honor.
Case of Baldwin versus Central Iowa Hospital and doing business as Methodist Center is hereby submitted. We'll have just a quick pause while the attorneys get ready for the next case, oral argument for Kono versus D.R. Horton and State of Iowa Civil Reparations Trust Fund.
We'll now hear oral argument in the case of Kono versus D.R. Horton et al. Mr. Weinhardt, are you ready?
May it please the court, counsel, Mark Weinhardt along with co-counsel Danielle Shelton and Jason Smith for the defendants D.R. Horton Incorporated and D.R. Horton LLC Iowa doing business as Classic Builders. This case involves a construction site accident that did not cause a death or substantial permanent physical injuries and yet produced a jury verdict of more than $20 million. The defendants here, by any measure, had the minority of the fault causing the accident. Multiple and overlapping errors require relief from this court. We start with the error of even submitting this case to the jury because there was no submissible claim that either of the defendants had a duty to the plaintiff. It is a rule in this state's tort law that employers of independent contractors do not owe a general duty of due care to their contractors' employees. That's been the settled law in Iowa for decades. There is a reason for the rule, which is that the responsibility for safety should be placed at the place closest to where it will do some good. That is, with the subcontractor who is experienced with the craft and who understands how to take precautions to avoid danger. And this court in recent years has affirmed in the Van Fossen and McCormick cases that that policy rationale supports the rule for which we advocate.
Look to the second restatement or the third here?
First, very big picture, this court should follow its own precedents rather than trying to sift through either the second or the third restatements. If the court spends time, and this is true for both the retention of control issue and for the peculiar risk issue, if the court sifts through the various restatement sections that have been proffered by opposing counsel, it will find that they are confusing and inconsistent. The purpose of the restatements is for scholars to survey the law nationally and find consistency in it and then enunciate that consistency. This is an area for both of these doctrines where there is inconsistency, and as a result, the restatements are confusing. In both areas, this court has issued a series of decisions that analyze and quote those restatement provisions at length, and so they are baked into this court's jurisprudence, but in both doctrines, this court's jurisprudence would lead it to reject the claim that was asserted here. To Your Honor's specific question about the second versus the third, we reject that this court would adopt restatement third, section 56. There are several problems with that, but the biggest is, in addition to the fact that only 4 jurisdictions nationally have ever cited it with approval, it is that Restatement 56 converts the duty analysis from one at law, which has been this court's tradition for many decades, to one that is determined as a matter of fact. It's determined for the jury. That is contrary to this court's long line of precedents and contrary to what this court said in McCormick, which was that when it adopted the beginning of the Restatement Third, Section 7 in Thompson versus Kaczynski, that the rest of its jurisprudence regarding duty remains good law, and it should remain good law. By the way, if we were to take counsel's suggestion and use Restatement Section 56 as the basis for duty, this court would still have to reverse and remand, because the duty theory that was submitted to the jury was based on OSHA regulations. It was not based on either of the duty theories that are advocated in this court at all, and it was submitted to the jury as a question of law, and if 56 is the law, then the jury is going to have to decide whether or not there was a duty, not the court as a matter of law.
I'm reading 56B of the third restatement. How does that change the analysis necessarily? I mean, we might or might not disagree with your argument, but it says, when an actor entrusts work to an independent contractor but retains control over any part of the work, the actor has a duty of reasonable care as to the exercise of the retained control. What's wrong with that proposition?
That sort of thing can be done all the way through the restatement provisions in both the second and the third. Each side can find provisions in the restatement that will support their view of the law, because elsewhere the third does talk about how this becomes a factual matter, or it can be a case-by-case matter. And so I think the difficulty is that the restatements, because of the confusion in this area of the law, don't yield clear rules. This court's precedents yield clear rules. So, for example, in the retention of control area, starting with the Porter case, this court has ruled, we think quite clearly, that it is not simply that there is a contractual right to oversee work, but rather that there is an exercise of that contractual right, that there has to be actual control. In the Downs case, this court particularly talked about the exercise of control on behalf of the general contractor before it can be liable for injury to the employee of a subcontractor. The Huffnagel case, citing Porter, has language quite similar to that. And so there needs to be an actual exercise of control in order for there to be a duty obtained by the general contractor. Yes.
If I understand the theory of the plaintiff's case as it was tried, it was the lack of control was kind of the negligence or the lack of supervision. But then on the duty piece, it's an assertion that they do have control in some legal sense. Is it? If I'm misstating it, please correct me.
Court has it exactly right. The closing argument from plaintiff's counsel is there is not a shred of evidence that D.R. Horton, collectively, we'll talk about the difference in a minute, there's not a shred of evidence of any exercise of control over this work site. Yet at the same time, their proffered liability theory here depends on an exercise of control. And so the facts adduced at trial and the theory advocated here go in different directions. In addition to the exercise of control, the control has to be granular. So the Hernandez case from the Court of Appeals, which has been cited more than once with approval by this court, looked at whether or not the general contractor had exercised control over the operative detail, even though an inspector came around every 3 hours to see how it was that this guy was doing in cutting gas pipes underground. That still was not enough control over how he did it in order to impose a duty. I'd like to turn then to the, yes, sure.
It seemed like at trial that Exhibit 56, the safety manual for D.R. Horton, played a pretty large role. Was that part of the contract? I think at summary judgment there was maybe some evidence that all subs were required to sign that. Maybe that's why it got past summary judgment. But was that manual part of Royal Plumbing's contract?
Part of the contract. I'll tell you where the contract is. It is Exhibits 45, 46, and 47. 45 was a master contract between Classic Builders, which was the predecessor of the D.R. Horton entity. Before the D.R. Horton LLC in Iowa acquired Classic's operations and assets, Classic had a standing master contract with Royal Plumbing, and then when they would work on particular projects, they would have exhibits for those particular projects, and 46 and 47 are the exhibits, and 45 is the master contract. That master contract said that the subcontractor and all employees are required to fully comply with and implement all governing laws, OSHA, pertaining to safety standards. And the exhibit, this is 46, said subcontractor shall utilize OSHA-compliant trench protection as needed during the installation of the water and the sewer laterals. So the agreement between the parties was plain that this was on the subcontractor, the one closest to the work, in order to get these things right. The only contract right that D.R. Horton had was the general superintendent's right, which wasn't good enough in Porter and isn't good enough here, to inspect the work to make sure that it's being done in compliance with contract specifications.
That went around and told them to wear hard hats. Where does that right come from?
So that would come within the general right, although actually the record evidence about this hard hats thing is a lot murkier than is portrayed by the plaintiffs. And the fact that the only evidence that they can come up with of any exercise of control is hard hats, when the problem here is trenching, and trenching is literally in the contract for the subcontractor to get right and follow OSHA, I think is evidence that that's where the duty properly lies. I do want to talk for a moment about the peculiar risk issue, and this court's decision in Robinson is completely dispositive of that. It is also a trench for a residential plumbing project. It is also a failure, allegedly, to take proper care to keep dirt from coming off a vertical wall. It is also an injury that happens when the dirt comes off the vertical wall, a cave-in. It relies on the Peterson case from North Dakota that specifically calls these episodes cave-ins, and this court determined that there was no duty because this was not something that was inherently risky under Restatement 416 and 427. Robinson is not an outlier, but it is rather part of a long series of cases that add up to the proposition that no plaintiff has prevailed on this peculiar risk theory since the 1970s, including, for example, in this Hernandez case with the Court of Appeals, approved by this court, where a guy is in a confined space underground, cutting and capping natural gas pipes that still have the gas going through them at the time of the accident. Or the Downs case where a guy is with a nail gun standing on scaffolding trying to hold his balance. Or there are several cases about being very high up on industrial roofs, or the Fawson case.
Other states like I think it's a Beckman case from Montana.
The Beckman case from Montana would, if the court accepts that invitation, do an about-face not only on Robinson, but I submit it would do an about-face on all of this other line of cases about peculiar risk that I have described. Because if the court starts down this road of finding ordinary things that can be solved with conventional methods of safety as being evidence of particular risk, I think it quickly gets to the point of disavowing that doctrine. And then we get, again, I think, to a situation where duty is determined factually rather than legally. And indeed, but
In case seemed, I mean, that court did an about face, but it seems like that they were at least convinced by the example that was provided in the restatement about logging. It's not speeding is kind of, don't speed, that's a regular safety thing, but how you connect or how you contain logs on a semi is more specific, and that was a peculiar risk. Are you not convinced by that, or why should we not be convinced by that?
If you look at the whole of the restatement, big logs on a highway are an unusual circumstance, and they present an unusual danger not just to the truck driver, but to people who have nothing to do with the truck and the trailer. Whereas in these workplace accident situations, the risk is generally presented to people who are there doing the work, like Mr. Kono here. And so I think the rules are different there. I think where you have a controlling on all fours decision here that perhaps, unlike some states, is consistent with a long line of this court's cases, that this court has not been presented with a reason why it should do a complete about-face on that body of law. I'd like to talk about the parent and the subsidiary issue for a moment. D.R. Horton, Inc., which I'll call the parent, is a large public company doing business in 36 states. D.R. Horton-Iowa LLC is the entity that only conducts the Iowa operations, and it purchased the assets of this Classic Builders. One of the things that is critical here is that the contract for the work by Royal Plumbing is entirely in the hands of the LLC, the subsidiary, not the parent. And the reason is, as I mentioned before, there is a master contract that was entered into 2 years before Classic Builders sold its assets to the subsidiary, and that is the contractual relationship. And the later exhibits, the evidence in the trial record is clear that although the naming is odd, you can tell from the address and other things that the entity.
The naming is odd. It says D.R. Horton, Inc., Iowa Division. How would Royal Plumbing know that there's a separate LLC that's separate from D.R. Horton, Inc. from that?
Because, well, first of all, there is no such thing as D.R. Horton, Inc., Iowa Division. Like that's not an existing entity.
Right? Okay, and if you add something that says division behind it, why does that not just sound like what it says? It's just a division of D.R. Horton, Inc.
So the way you know that is who they are and what they're doing. For example, there is no individual in this case. There's no figure on the D.R. Horton side of the ledger until Mr. Cook, who comes in after the accident, who is an employee of D.R. Horton Incorporated. All of these are part of the old Classic Builders. And so for Royal, they're dealing with the same cast of characters that they always did at the same address.
Wouldn't fly with respect to D.R. Horton, Iowa, though, does it?
Well, so I think that fact pattern is evidence of why D.R. Horton, Iowa is the entity that they were dealing with. And to get to the point of how is it that you would impose liability on the parent, you would have to do it one of two ways. You would either have to plead and prove veil piercing, and there was no attempt to do that, or you would have to plead and prove independent tort. So you would have to prove that the parent had a duty, it breached the duty, the breach was the cause of damages, and that the plaintiff was damaged. There is not a serious suggestion in the record here that either of those things survives a directed verdict, but rather the suggestion is, well, you should have objected sooner or made more noise or you said something in your answer that made us think that the two sides were, or the two entities were the same. But error preservation happens at the time of trial. There's no obligation to raise things by summary judgment motion or anything like that. And
Inc. admit in its answer that it had a contract with Royal Plumbing?
not.
How? Explain why.
That the plaintiff's allegation sometimes used this collective term D.R. Horton, but sometimes the plaintiff's allegation said D.R. Horton, DBA Classic Builders. Classic Builders was identified in our answer as being the DBA of the subsidiary, but not the parent. And that is the fictitious name for the subsidiary, but not the parent. It was true at the time of these events. It's true in the Secretary of State's website this morning. And so when the plaintiff alleges Classic Builders, they're alleging the Iowa entity, and that's the one in paragraphs, I believe it is 19 and 20 of the petition that were admitted. Those are allegations about who the general contractor is and who the contract with Royal is. That's DBA Classic Builders that they're alleging, and that's what it was that we made the admission for.
You back to instruction number 19 on the OSHA standards. I guess just sort of more broadly, what was wrong with them? The district court found that there was a duty. So didn't that kind of merely detail what that duty was or what that standard was?
First problem is that the duty came from OSHA, and we objected at the time that OSHA regulations can't create a duty. We have argued in this appeal that they can't create a duty, and the plaintiff does not defend that it creates a duty. So the entire theory underlying instruction 19 is abandoned and has no legal support. But in addition, that instruction overstates the duty. It says the general contractor assumes all obligations presumed as employer obligations under OSHA excavation standards, whether or not the general contractor subcontracts any part of the work. And it goes on to say the general contractor assumes the entire responsibility for construction safety under the contract. The problem is that if we're going to find a duty because of peculiar risk, or we're going to find a duty because of retained control, we have to instruct the jury about what that duty is, and then that's what they do to measure the specifications of negligence against. And that's not what happened. So if we're going to adopt either of the theories that are proffered here, we still have to have a trial about those theories, not this one. And there were no discrete specifications of negligence for the Horton defendants in this case. Unlike the three released parties from Royal or Mr. Kono himself, where there were discrete specifications of negligence in the instructions, there's nothing other than 19 and 20, which are just sort of a declaration of this plenary non-delegable duty, and then sort of a mishmash of questions about the evidence. Thank you.
Time, and you two will work that out on between yourselves.
You may please the court. I will take 15 minutes and leave 5 minutes for the punitive damage discussion, of course, subject to what the court would like to do. So I want to start very briefly just with the entity issue, because I really do think that it's quick, and it really does, just like our brief said, simplifies the issue here. So yes, they did admit that they owned the property, that they were the owner. They admitted that they were the subcontractor, they being Inc., the parent company. And that follows from the fact that in paragraph 13 of the petition, we collectively define both of them as D.R. Horton. In paragraph 15, we use that collective to say the collective use Classic Builders. From then on, D.R. Horton Classic Builders is both of them.
I read, like in paragraph 27, they say D.R. Horton, this collective entity, contracted with Royal Plumbing. Now, why couldn't that just mean, I agree it's ambiguous, it could mean they both contracted with Royal Plumbing, there's two entities that did, or it could just mean an either-or scenario, which is what they're arguing now, that one of the two entities did. And before trial, they made it clear that they were taking the position that the parent company didn't contract and wasn't connected with this scenario. So why isn't that enough to preserve error?
And it's not just error preservation. There's multiple issues at play here. So one, they admitted that they were the owner. The contract said Inc., and then discovery closed. So the idea that we would be able to get into whether this is one or two entities, they treated themselves as one the entire time. And then they didn't say anything before trial. In fact, only the LLC filed a motion in limine asking for Inc. to be out of the case, which is a strange thing to do. The brief said it was Inc. that filed it. That was actually only the LLC. And then if you move on to count 4, specifically, D.R. Horton in its answer was unambiguous. It said D.R. Horton admits that it was a subcontractor, and D.R. Horton for them too was also the collective.
I read it, it's all this collective, isn't this collective definition, and that could mean either or. I mean, or it could mean both. And then, you know, as the evidence played out, it's clear it wasn't both. So what's wrong with that?
Collapse them, and I think that what you heard, that the evidence was less than clear about whether it was both or not. The contract at issue says Inc. And then if you look at one of the deposition transcripts that was submitted, this is Josh Moulton, the person who signed for D.R. Horton in that contract, which says D.R. Horton, Inc. He was asked about these contracts, and he said, I would assume everyone knew it was D.R. Horton, the actual, publicly traded entity. So even the person who signed it thought Inc., it says Inc., he thinks it's a publicly traded entity. So I guess that is where we are here. And then, of course, they even further invite error on the jury instructions by asking the jury to include them all as one at the end of the day.
They'd lost the directed verdict. I mean, I think it's pretty clear. You lose the directed verdict, you don't have to renew the position in the jury instructions to preserve error. That is pretty clear, isn't it?
Issue you're talking about. It depends on if you're talking about the damages, you're talking fault, what are you talking about? Because now we have a clean case against LLC.
In the case at all, they had lost on that, so they don't have to renew that in the jury instructions, right?
Unclear about what they mean by in the case at all, because they say introducing any evidence about them was tainted the case against LLC. They didn't move to dismiss themselves, so they should have been involved in the case. I'm happy to continue that, but again, the evidence on the contract is it is Inc., and their person who signed it said that he thought, and I should say this is at D488. It's a deposition transcript that was read to the jury at page 17. Moving on to the duty issue and really the retained control and the restatement. Everything you read in there, everything you read in the decisions, retained control can mean. You retain the right, and right is used multiple times throughout the restatement and in this court's decisions, or you can exercise that control. And it's not necessarily control over the particular thing that led to the harm, because this also applies to possessors of land. Like, did you relinquish control of the land, of the job site? And this contract makes clear that it is no, they did not do so. They say that Porter says that Porter stands for the proposition that control has to be exercised. Everything about Porter is, in fact, all about the contract. When Justice McCormick uses that phrase, practical construction, that was just a phrase that was popular. I think he used it more than anyone, if you go on Westlaw, in the 60s or the 70s and 80s for course of dealing. And it was all about the contract. In fact, at the end of Porter, he says, such cases as Cobus versus Formet, which is an Illinois Supreme Court case, where an owner retained control of building construction through an architect, are distinguishable as illustrating the kind of partial retention of control required for application of the restatement rule. Cobus was all about contractual control. In fact, the fighting issue was whether they had to exercise it, and the court said that they did not. That case was not a restatement case. It was a case about a statute in Illinois, but the issues were exactly the same. And Justice McCormick relied on that and said, yes, that would have been enough. And if you go to Cobus, what was enough in Cobus? That the architect may order changes in the work. The architect shall have general supervision of the work and is authorized to stop work if necessary to ensure the proper execution. That kind of general supervision of the work, that is what we have here.
How do we explain the outcome in Porter then? Because Porter, as I read it, it kind of strikes me as they have the contract language, but they don't really exercise it. And so
it's not about, the exercise part of it is about how they interpret the contract. And if you even look at the pages that D.R. Horton submitted on the appendix to it, what Justice McCormick is saying is through their course of dealing, they have reconstructed the contracts. So under the contract, the architect did not have that kind of control. The architect could only show up and approve the work or not approve the work. That's what practical construction means.
That what they were actually doing is what mattered, and that's their position, right? I mean, here let me read the language from the two cases. DHI job superintendent shall maintain the authority to direct all work unless otherwise stated shall be awarded final decision. Porter, such inspectors shall have full authority to pass judgment upon all materials and upon the manner of doing the work, and their judgment rejecting any material, substance, or manner of work shall be final unless it's revoked or modified. How do you distinguish those?
Justice McCormick said was that as written, the contract was broad enough, but as the parties interpreted it and as they reformed the contract under the practical construction, that's what he meant. That's why he cited Corbin.
I mean, I just see, yeah, I mean.
That's why when he talks about practical construction, he cites Corbin. He's not citing any kind of tort treatise. That's why he cited Williston. And that's why if you look at his opinions, he more than anyone else used that phrase practical construction to say course of dealing. And every one of those cases, every single one was a contract case.
A course of action. I mean, that is what we're talking about.
Contract. And now we're talking about whether, so getting back to it, does it
form the contract? It helps, well.
I hear you, but I think the point is that he was only looking at the contract and what the contract said about retained control. Why would you look at the contract at all if all you do is exercise it? Who cares what the contract says? If the only question is whether you exercise control or don't exercise control, the contract matters none. So the fact that all of this was about the contract and about the terms of it, that's what matters. And that's what this restatement 56 and the difference between 414, the second and the third, there really isn't any difference. And I take to heart Justice Scalia's criticism of the restatement sometimes that they're making law instead of trying to find what the law is. If you
meetings, they admit they're making law.
Look at this one though, they are saying in 56, they're going through and talking, they aren't trying to change 414 at all. They're just talking about what courts have done. And if you look at Washington Supreme Court, Texas Supreme Court, North Dakota Supreme Court, there are multiple cases in which they say, yes, it can either be retained in the contract, a right of control, which is what 414 says, or it can be exercised. And those were all before the third. They're not adopting the third. That's their application of the second.
I think Mr. Weinhardt said that you've effectively abandoned kind of the OSHA regulation theory of liability on appeal. Is that right in your view?
Not liability, but of duty. Yeah.
In that context, then, how do we deal with the jury instruction on 19 and 20, which candidly to me almost read like directed verdict instructions? Like, I'm not sure, based on these instructions, what the fact issue is and how they would avoid liability. So what do we do with that instruction?
Standard instructions allow you, when there is an OSHA violation or some other thing that is evidence of negligence but not per se negligence, it lays it out and says this, and then it says this is evidence of negligence but not necessarily conclusive of. And that was the main objection in those objections to the proposed rules that Judge Hanson didn't submit, and he changed that. So again, there's a serious error preservation problem with their objection. I'll go back to that. But there's nothing different about this. And did the jury have to know all these details? Well, maybe they didn't have to, but they needed to know that, one, the OSHA standard applies, and why does the OSHA standard apply? It's because the general contractor can't get out of that. And then here's the OSHA rules, which say that you can't use these types of methods in type C soil, and there's a dispute about whether it's type C or type B. And if you find a violation of this law, then that is evidence of negligence.
I'm not sure that it says you can infer negligence, or it says, in no case will the contractor be relieved of responsibility, blah, 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 blah. I think it says that they are negligent. Like, if there's a violation of OSHA, they are negligent, not you could find negligence.
It says a violation of this law is evidence of negligence. That's instruction 20. It
Says, in no case will general contractor be relieved of overall responsibility for compliance with OSHA requirements. General contractor assumes all obligations prescribed as employer obligations under OSHA standards, so.
basically just a copy and paste of the OSHA regulation that was in the record as an exhibit without objection. And if you look above there, it says a violation of this duty is evidence of negligence. That's at the top of 19. And again, they have a very serious error preservation problem. It would have been very important, very helpful, because these changes about evidence of negligence as opposed to negligence per se, that was the focus of their written objection that was submitted 3 weeks before to Judge Hanson. They gave no specific objections to this when Judge Hanson took what they had said, and they didn't say anything at all. I have a hard enough time, which I appreciate that you probably do too, going back and forth between the written objection, between how the written instructions changed, and thinking, how does this all line up? If you have a summary judgment motion, the judge doesn't rule on all issues. If you just say, I incorporate in your 1.9042 motion, I incorporate all my other issues because I think you missed some, and you don't specifically say, look, Judge, thanks for changing this, thanks for doing this, but you missed this issue. Does that preserve error? And that's where everybody has a lot of time. The rule coming out of this case should be, if it wasn't clear enough, that it's not enough just to say I incorporate all my objections. If the judge changes the instructions, you have to say what you still care about and explain why.
So I thought that part of 19 didn't change. It did change.
The top part said a violation of this duty is evidence of negligence. And certainly the judge still copied and pasted what the exhibit was, what the standard was, that they being D.R. Horton could not get out of it just because they're the general contractor. And then 20 tells you what that general OSHA standard is. The rule is you have to read your instructions together too, not just in isolation. And if you go to 20, then it says, here is the standard. There's a dispute about what type of soil it is. At the end of it, it says a violation of this law of OSHA is evidence of negligence. Such evidence is relevant and you should consider it, but it is not conclusive proof. And that was changed from the proposed instruction to which there was only an objection to. There was never a specific objection to this change.
And to the peculiar risk, if we follow Robinson, does that close the door to recovery under a peculiar risk theory, or would we have to overrule that to allow a duty under that inherent danger or peculiar risk?
Limit Robinson to its facts, and when I said a top in the brief, it rolled. So you can have a risk of anything rolling when you're not just in a trench, but anything else. So a complete cave-in of that is something different. But I think there are some statements in this court's opinions, I think, that need to be cleaned up, and I think ultimately, I think because they have retained control, it doesn't matter. I think ultimately the court needs to decide whether peculiar risk exists at all or if it doesn't, because the argument they are making, it does not exist, because the only thing it exists to is ultra-hazardous activities, to which you don't even need a peculiar risk instruction. So that part of the restatement in this court's holding is either gone or needs to be cleaned up perhaps, but this may not be the case because retained control is enough.
Control, was there any evidence that they actually exercised control on the trenching?
There was evidence that they had, quote, dinged people for not doing proper techniques before, but it wasn't necessarily related to this particular instance. And if I could...
Part of it, is it kind of your position that because they had a superintendent, then they're pretty much responsible and liable for everything?
In control it's a risk because I'm sorry, I'm confusing myself. Retained control is because they said they want, as part of their business model, they want to be able to tell you what to do. They are, quote, the boss. That's what the evidence is when they are on there, when their superintendent is there, because they use all of this labor, and but they don't want to give up control. It's kind of like that person who just coordinates getting people in.
They've retained all of that control. Doesn't that, I mean, is your theory that then pretty much anything that goes wrong on this site, they have responsibility for?
Have to retain that control. So they have the same, they are also the owner of the land, so they have a reasonable requirement to make sure that it's a safe workplace.
This is like Hernandez published Court of Appeals case. The court really focused more on kind of the operative detail of what the particular risk was and the particular conduct was. And so can you talk about, is it enough just that you retain control over everything, or does there need to be some showing that D.R. Horton retained control with respect to how the trenching itself was done?
It's like a possessor of land. They didn't relinquish. It is not control over a specific thing. They didn't relinquish control over the land, like to the subcontractors. Right.
Hernandez doesn't come out that way at all.
And the subcontractor, Royal Plumbing, left D.R. Horton, doesn't do D.R. Horton stuff anymore, because he said, look, other contracts are like 2 to 3 pages. You do the work, you get paid. I don't essentially like all of this, so he left. He doesn't do that anymore. They did, however, continue to subcontract with Russ Hall, who was the guy who told Tim Kono to get the F in the hole, even though at closing argument, they said that he had a conspiracy to cover up the whole accident after. They pushed the dirt in there, but they continued to employ him for 2 years.
I'm not addressing Hernandez. Tell me why we shouldn't follow what Hernandez said and look at kind of specifically what the conduct that caused the accident or the injury was, as opposed to just this broad everything that happened.
Completely different rule, and it would be completely inconsistent with 414 and what it...
14 case, it was retained control case.
It's inconsistent with 414. And 414, the control principle, as this court has said, is the same as an owner and possessor. And those cases are whether you give up or you relinquish control of the property. I know I'm eating into the state's time, and I'm sure they are not happy with me, but I'm happy to answer any other questions if the court has them. Thank you.
May it please the court, counsel. The state has an important public policy interest in deterring harmful conduct and ensuring that it's not repeated. That's why the state has an explicit interest in this case and why we're here as an intervener, not just an amicus. In particular, there's an important public policy interest in ensuring that when a company retains control, and that's supported by not only the contract and the manual here, but by the testimony of Seth and Joshua Molt.
I mean, I have to say, I have trouble seeing this as a punitive damage case. It's a punitive damage case where there had been no prior reports of accidents involving this subcontractor. It's a punitive damage case where the defendant didn't even find out about the accident for a significant period of time thereafter. They weren't on the scene. Tell me, I can understand negligence. How do you get to the level of recklessness?
Down to viewing this case through the proper lens and not just kind of the accident itself, but the events both before and after, both of which are relevant to punitive damages. That's this court's holding in McClure v. Walgreens. And here the conduct after is particularly telling because even after the accident, there was no meaningful investigation, no changes in practices, and they continued to employ not only Royal Plumbing, but Russ Hall. And that, even putting aside conduct beforehand. Correct. So you have a case here where Royal Plumbing's doing thousands of trenches for D.R. Horton, and per its own contract, per the testimony of its own executives in deposition, there's supposed to be a job superintendent there. They're supposed to be enforcing these practices, and Royal Plumbing likewise testified that it never undertook any of these practices. At that point, D.R. Horton should have been stepping in and doing something, especially it's important here to remember that we're also looking at, with punitive damages at not only the actual harm, but the potential harm. And the result when there is a trench collapse, when someone is buried alive like Mr. Kono was, the result is almost always death. And that's the actual harm we're looking at, or the potential harm we're looking at when it comes to the punitive damages analysis. The point, because punitive damages exist not just to compensate, don't exist to compensate a plaintiff, they exist for a retribution, punishment, deterrence. We take that broader view of what is the conduct we're looking at, what is the harm that we're looking at, and here it's significant and would support the punitive damages finding here. This was not a mere accident.
We decide that the parent company did not belong in this case, directed verdict should have been granted. Is that an automatic requirement of a new trial on the punitive damages evidence, since part of the argument for the size of punitive damages was the size and wealth and revenue of the parent?
I don't believe so. Again, I would actually point the court again to McClure, where in that case, not only was looking at just general net worth proper, but specifically not just kind of net worth within Iowa. You look generally at kind of the kind of financials involved. I believe you could still get to the same punitive damages judgment here. You also have other evidence as far as kind of the reprehensibility of the conduct and the indifference, both of which were very high in this case.
Evidence of the Iowa entity, if that was the only proper defendant that should have been kept in, wouldn't their revenue have been overstated if you're relying on the national or parent company's revenue to get to that? Wouldn't that skew it?
Is there was no Iowa-specific revenue presented. The only evidence was what was presented from kind of the national entity in this case. That was the only evidence the jury could have considered with respect to net worth.
It was error to keep the parent in the case, then that has to be vacated, right?
I'm not sure that's necessarily the issue. I mean, I think this goes to some of the issues with having the parent company in there and some of their conduct, such as only providing financial evidence from the parent company and not any evidence from the subsidiary. You have to get around that issue first. I see that I am well over my time. I appreciate the court listening, and we state would ask the court to affirm. Thank you.
Thank you, Your Honor. I'd like to say a couple of things about the duty question first. The Porter case controls here, and it is not the case that that turned on contractual interpretation. If we want to talk about Mark McCormick's proclivities, I can tell you he would not have found that language as expansive as is contained in the Porter contract was amended, not just not exercised, but was amended by the course of conduct by the parties. Indeed, the plaintiff in Porter argued that the existence of the right of control was sufficient to create a duty, and this court rejected that. With regard to the control over the land that Mr. Koopmans referred to moments ago, the word premises does not appear in their brief. We explained in ours why premises liability doesn't provide an independent avenue and why control is the same, whether it's under retained control or premises liability, and there was no response in their brief. Regarding the peculiar risk issue, I'll just say one thing. Counsel's suggestion is, well, let's limit Robinson to its facts. That is going exactly down the road that I think would be perilous for this court. It would be starting to make duty determinations for the jury. The Robinson line of cases says, and indeed some of the language in the restatement say that we decide these duty questions category by category. We don't say, is trenching a peculiar risk this day, but it's not a peculiar risk that day. We decide for trenching as a category, as we have decided for high industrial roofs as a category. Categorically, Robinson got it right, and we should retain that distinction. With regard to the presence of the parent in this case, the pleading from the plaintiff was frankly really ambiguous. And so whatever got answered was also ambiguous. At that point, if the plaintiff is serious about making this a punitive damages case based on the financial results of a public company, it was incumbent upon them to send some interrogatories or take a corporate representative deposition and figure out exactly what the relationship between the two was. They didn't do that. There's no obligation on the defendant's part to file a motion to dismiss or file a summary judgment motion or something like that. Trial is the place where the sufficiency of evidence is determined, and they made a timely, fully argued directed verdict motion. At that directed verdict motion, in order to get the corporate parent to the jury, the plaintiff would have to show evidence to meet the veil-piercing elements under the Briggs case, for example, or to demonstrate duty, cause, breach, and damages. They didn't do any of those things, and today their position is that these admissions in the amended petition cover all of that. They provide all of the evidence that would have supported all of those elements that I just described. That is not in the answer or in the amended petition. And indeed, it was the plaintiff, not the defense, that put the asset purchase agreement demonstrating the corporate separateness between the parent and the subsidiary into the record. With regard to the instructions, we submitted written objections to those instructions that plainly said OSHA regulations do not create a duty. And there was no material difference between what we objected to on that point 3 weeks before trial as there was at the time of the charging conference. And at the charging conference, we had an expert witness who testified to other OSHA regulations that were positive. They were defense-friendly. Those were kept out. It was particularly in instruction 20, unidirectional, and that's the exact same error that this court found objectionable in the Alcala case. For over 50 years, this court has established jurisprudence that allocates the responsibility between independent contractors and the parties that employ them. In order to hold on to his judgment, Mr. Kono is asking this court to rewrite or maybe tear up all of that law and start down a path where we start to have juries decide the scope of duty rather than having the courts do so in a categorical nature. That is going to destabilize commercial relationships and frustrate expectations. In order to have an orderly commercial environment, especially in the construction industry where we face a tens of thousands of units housing shortage in this state, this court should reverse and keep the law the way that it has been since at least the 1970s. Thank you.
Kono versus D.R. Horton et al. Is now submitted, and the bailiff may adjourn court.
Hear ye, the Honorable Supreme Court of the State of Iowa is now adjourned.